this courtroom, civil and criminal procedures occur Monday to Friday. The consequences of both civil cases and criminal cases are very different. For example, in civil cases, people come here to fight over money, property, divorce, child custody, and so on. The end consequences of those cases are, there could be a judgment against you to pay money, companies or person going after your wages, which will be garnish your wages, and also judges finalizing a divorce. But in criminal cases, the end consequences may be jail time, prison, or probation. If a defendant is put on probation, they'll be ordered to complete certain conditions related to their charges. Let's say for a DUI charge, that defendant has to take DUI classes, which also they are not able to drink alcohol, and they may do also community service. Another example could be a battery charge. The defendant can take anger management classes. He can be ordered to pay a fine, and also, of course, have no contact with the victims. We also have to remember that in civil cases, it's people against each other. They're suing people or companies suing other people. And in criminal, it's always the state versus a defendant. I enjoy working here at the courthouse, but the only time I enjoy seeing people is if they are coming to get married or if they come to witness an adoption. Other than that, I wish to see no one here, because that means trouble. So stay away. We are going to talk about common law. Common law is a body of law developed in England from judicial decisions. Common law refers to the body of law created by the courts and not the legislature. Judges write opinions, and these opinions are passed on over time and become the law. A perfect example is the corpus delicti rule. This is an example of English common law that still affects American jurisprudence today. A great example I talk about in my paper is an article that I found online. It's a true case. It's about a John Perry case that occurred years ago, in the 1600s, I believe. Perry's case is a false confession that led to the execution of 3 innocent people. John Perry was subjected to continuous and repeated questioning as to the disappearance of William Harrison. He ended up confessing that he, his mother, and his brother had murdered Harrison. Even though a body was never found and there was no evidence that they committed the murder, all 3 of them were executed. And then years later, William Harrison returned home. This injustice of Perry's case and similar cases that I'm sure happened like that before is what triggered the creation of the corpus delicti rule. In this video, I'll explain how burden of proof relates to a criminal procedure and discuss the legal elements of a crime. And it all falls on the state. Remember, the state, through the state attorney's office, are the ones making the allegations against the defendant. In other words, the state is accusing the defendant of committing a crime. That's why the state has a burden of offering evidence to prove the allegation against the defendant is true. This is called the burden of proof. And in a criminal case, the state must prove that the defendant is guilty beyond a reasonable doubt. The Florida Supreme Court has a definition for beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. So the burden of proof in a criminal case, it's beyond a reasonable doubt. But what exactly does the state have to prove to the jury beyond a reasonable doubt? The state has to prove each element of a crime beyond a reasonable doubt. For example, in a crime of burglary, The state must prove the following two elements beyond a reasonable doubt. 1. Defendant entered a structure, conveyance, or dwelling owned by someone else, and 2. At the time of entering, the defendant had the intent to commit a crime. So the elements of burglary are enter and 2. Intent to commit a crime. Another example would be a no valid driver's license. The state must prove following two elements beyond a reasonable doubt. The defendant drove a motor vehicle upon a highway in the state. 2. At that time, defendant did not have a valid driver's license recognized by the Department of Highway Safety and Motor Vehicles of the state of Florida. So the elements of no valid DL are 1. Defendant drove, and 2. Without a valid driver's license. Another example for a first-degree premeditated murder. The state must prove the following three elements beyond a reasonable doubt. 1. The victim is dead. 2. The death was caused by a criminal act of defendant. And 3. There was a premeditated killing of the victim. So the elements of a crime are those things the prosecutors must prove beyond a reasonable doubt in order for the jury to find the defendant guilty of committing the crime. And that's how the burden of proof and the elements of crimes relate to criminal proceedings.